So morning, Alan. It's the morning after the night before, and the Labour Party has just won a decisive victory in the UK's general election and is the majority government for the first time in 14 years. They've got some radical plans for employment law, which we're going to discuss now, I think. What I'm most interested in is the extent to which their employment law plans or proposals support or conflict with their overall strategic number one aim, which is to increase growth in this country. The stated aim for Starmer and Reeves is to increase economic growth in this country. So I think we're going to discuss some of the employment law plans that Labour has now, and we're going to score them out of 10 in relation to how we think each of these employment law proposals support or not the stated aim for economic growth. Is that right?
Yeah, it's been an amazing victory for Labour, one that was expected, of course, and they've had in their manifesto a number of proposals which are quite radical for employment law. We're going to go through some of those now, and as you say, let's see how they will impact on Keir Starmer's plans for economic growth. Will it support growth, and might it indeed hinder growth? We're going to score them out of 10. So let's look at some of the proposals. We won't go through all of them, but some of the more tastier ones from an employment law point of view. Single worker status, for example. As we know at the moment in this country, we have three types of status. You're either self-employed with hardly any employment law rights at all, in fact, none. You're either an employee with employment law rights, and after a certain period of time, you'll have stronger rights. Or you're a worker status, which is a bit of a mixture. You have some employment law rights, for example, the right to national minimum wage, but you don't have the full range of rights. Labour is saying this is far too confusing. They want it like the tax law position, John. They want to have you're either self-employed or you're employed. Now, that's really interesting. I think it may simplify things, but it may produce litigation over status. I don't know. People probably want to be self-employed, and the revenue may challenge this. HMRC may say, well, we think you're employees and you employers should be deducting PAYE and paying national insurance. What do you think about that, John?
Well, Alan, I think this is one of the more interesting proposals. I mean, it's one of those plans which superficially looks like a good idea on paper. You're going to simplify things. You're going to have not three statuses, but two statuses for employment law rights. There's genuinely self-employed and the workers. The issue is this. We have one of the largest practices in the country at Constantine Law for agency workers, and we're members of APSCO. Only a relatively small number of firms are members of APSCO. And if you conflate agency workers with employees, that gives agency workers a massive number of new employment rights, which they currently don't have. So agency workers can't bring claims for unfair dismissal, for example. And over 1 million agency workers got up and went to work today in this country. And there are more agency workers in the UK than there are in the rest of the European Union combined. So the extent to which we've got a really flexible labour market in this country is a really good thing. We get more people into work more quickly than any other country, Western country in the world, other than the United States. And if they conflate this status, I think there will be some challenges ahead, as you've said, for employment status, but also agency workers asserting all sorts of claims that they might not have done so far.
Do we think this is going to increase costs for business? I think it will. I think there could be a lot of disputes, a lot more red tape around it, a lot of challenges with HMRC. And I just don't think it's going to really support economic growth. I'm going to score this 3 out of 10. How about you?
I agree. I think that's about right. 2 or 3 out of 10 in terms of supporting economic growth. On one level, most people think this is quite a marginal issue, but actually it's not a marginal issue. So let me give an example. We act for some of the largest suppliers to nurses, agency nurses in the UK. And some people think there are 2 categories of nurses. There are agency nurses and substantive employees. Actually, the vast majority of the time, as you know, is that they're one and the same time, the same person. So because the NHS doesn't pay nurses enough, they top up their wages by going agency, sometimes at the weekend, and they get higher rates. So where does that leave that person who might some of the time be an agency worker other times of the week an employee. So I agree with you. I think this is superficially simplistic, but actually quite a complex proposed change. What do you think the next biggest change is, Alan?
It's got to be day one employment rights, I think, John. In my time in employment law and in your time in employment law, we've never seen a day one unfair dismissal protection, for example. We've always known that people have protection from discrimination even before their employment starts, for example, during an interview if their own questions are asked. But we've never seen day one employment protection for unfair dismissal purposes. It could lead to more caution in employers hiring people, being frightened that they might have somebody and after 2 or 3 weeks they're not working out, they need to dismiss them, but they can't do it very easily.
Look, I agree. I think most employment lawyers would think this is the single most bonkers idea that the Labour Party has got. I thought that they wouldn't put it in their proposed white paper before the election. They have doubled down on that before the election. We went to the ELA conference recently. The vast majority of employment lawyers thought that this would not be the position, but it is the stated position of the new government that employees, when this law comes into effect, will have day one unfair dismissal rights. If that happens, that is going to result in a surge of claims in the employment tribunal service. I think you and I both recognise that. And I do think that access to justice is a human rights issue. And so it has been a human rights issue in recent years. The underfunding of the employment tribunal service means that often there are cases that are delayed for 18 months, 2 years, sometimes longer, for simple unfair dismissal or discrimination claims. If the Labour Party introduced this day one rights, I think it's going to smash the employment tribunal system. What do you think?
I think there's a good argument that it may well break the employment tribunal system, John. We saw during COVID the employment tribunals adapt in how they operated hearings. So they didn't have them in person. They switched to online video hearings. This was a first for the tribunals, and it's now become the norm. It's helping to eat into some of the backlog. But if we get these day one rights, it's possible that we may see caseloads increase by literally the thousands, if not tens of thousands. And it's also possible that there'll just be too many. The tribunals are under-resourced to cope with it. And we may well see the system break, which would be absolute tragedy and a denial of access to justice. So, yeah, we're not going to score this one very highly at all.
Well, I'd probably score this 1 or 2, Alan. I mean, where do you think it will end up? Do you seriously think in 6 months' time? Well, let me ask you, what do you think in 6 months' time, by Christmas, the qualifying limit for unfair dismissal will be?
I think it will be 6 months, as I've said. It was once 6 months. It then became a year and then 2 years. But the Labour government have pledged to have day one rights. I don't believe that business will allow them to introduce day one rights, and we'll see a great opposition to this during the consultation leading up to the change in legislation. But I do believe they'll bring it down as low as 6 months.
I think that's right. I mean, again, 6 months would be radical. I mean, I think it was in the mid-70s that there was a 6-month qualifying limit. It then went up to 2 years under Margaret Thatcher's Conservatives, then 1 year under Tony Blair, back up to 2 now. If it's 6 months, that would be radical. I'll tell you the one thing that I think that will happen as a result. It will result in the rewriting of most employment contracts in this country. Why? Because the probationary period for most employment contracts in this country is currently 3 months. If you put the qualifying limit for unfair dismissal for 6 months, and the probationary period will be 5 months. And so you will find that millions of workers, millions of employees are going to be asked to re-sign their contracts. Certainly all new hire processes will see an increase in the length of probationary periods. So for every new proposal which the government will introduce, there's going to be a reaction from business, which may be contrary to what the government had originally intended. But that's part of the give and take of employment law, which is why we love it. What about the next biggest proposal, Alan?
I think the next biggest proposal is the ban on 0 hours contracts, John. We see a lot of companies in like Tesco's and in the logistics sector. I've got clients in the logistics industry who employ a lot of casual workers. So basically, they don't have to offer them work. Employees are not bound to accept that work. But when it is offered and they do the work, they'll be paid accordingly. This has not been a popular move amongst employees because it restricts the flexibility. There is some flexibility, but they feel bound to comply with these 0 hours offers. So I think that's the next one. But whether it will Let's see. I think it will damage business. To be honest, I think it will damage that flexibility, that ability to adapt and change the working practices in accordance with what business needs. And I do think this is a move that will not support economic growth. And I give it a 3 out of 10.
I think you're better qualified to speak than I am on this subject because you've got a lot of clients who are in the logistics industry in particular, haven't you? And so it's those drivers that are working at Tesco's and Sainsbury's, etc., that are on 0 hours contracts, and it'll be those are big PLCs that you've said that will be lobbying the government, saying, "Hang on, this is how we manage our logistics supply in this country." And we rely upon 0 hours contracts. It's not as if these people don't get paid. They do get paid. They just get paid when they work. Labour understandably wants to introduce a greater degree of certainty or predictability into how people will be paid when they work. But there's going to be a big battle here between big PLCs on this subject and the government. And it's going to be really interesting between now and Christmas to see who has the whip hand in these negotiations. So I agree. I think this is 2 or 3 out of 10 in supporting growth. What do you think the next biggest thing is? I think we've done 3 out of 5 that we've highlighted.
Yeah, John, I think the next biggest thing is the ban on fire and rehire. So what this means is if an employer wants to change a term in a contract, they can't do it unilaterally, otherwise that would be a breach of contract. So they first of all consult with the employee and try to persuade them to agree to the change. If the employee doesn't agree to the change, then employers have been using this fire and rehire method to force the change through. And what they do is they say to the employee, if we can't agree this change, we're going to serve notice to terminate your contract. And at the end of the notice period, we're going to offer you a new contract with the change term in. Now, that will be a valid change for contractual purposes because they gave notice. And as long as they've consulted and they show a business reason for the change, it won't be an unfair dismissal. So employers have been using this method for a long time to push through changes, to force them through. This isn't popular at all. We saw issues when P&O tried to change terms that were very unpopular in the press. And legally, this works. There's been a lot of backlash against this in the press over the recent 12 months. But I think, just let's go back to basics. Contract law is about reaching an agreement between 2 or more parties. And this is fundamental contract law. So the ability to terminate a contract is always there. Why should an employer not be able to terminate a contract and then offer new terms? So there's a fundamental challenge to employment law, which will be very interesting. But I think it's going to be a big cost to businesses. And again, I don't give it more than 4 out of 10. Over to you.
I probably think amongst UK PLC as a whole, I'd probably score this 6 or 7. In that, I think what the new government are saying is we don't like how PLO and other large, organisations have conducted themselves in recent months. But the fact is that this is relatively rare in terms of the totality of the number of fire and rehire situations there are in the UK as a whole. I mean, this is relatively rare as an employment law issue. I think you would probably agree with that. So I would describe this almost as a contingent risk. It happens in a small minority of instances. So I don't think this is massively impactful. Something like the changes of agency workers, which is happening on a daily and hourly basis. There are agency workers out at work as we're recording this podcast. That's a much more important issue because if you increase their employment law rights, then that's an absolute liability on their employer on a day-to-day basis as opposed to a contingent obligation. What about the 5th one? But then I have the big elephant in the room to discuss at the end of it.
Yeah, that's fine. Look, let's look at something that's really something of a modern age. The right to switch off. It's never been easier for an employer to contact their employees. It's not longer phone calls or emails. It's WhatsApp. It's instant messaging. And, there's a lot of talk about stress, mental health, and when we're not working, we shouldn't be contacted. I think if this proposal is brought in, I think businesses would incur more costs as they need to implement policies and systems to make sure that employees have the right to disconnect and can enforce that right. Employment contracts are going to have to be updated, new guidelines created. perhaps new technology invested in to monitor and enforce those policies. Again, as something that's going to support economic growth, it's a 4 out of 10 for me.
I agree with that. I mean, I've had two thoughts about this. I mean, I think it's a really interesting idea. I think they have introduced it in New Zealand. I think they're thinking of introducing it in Ireland. I've got two queries in relation to it. One is, how do you monitor it properly? You know, because there is more intrusion into all of our working lives because of IT. You know, but also, and you're much more IT aware than I am. IT is also a great liberator. It makes us more flexible, and so I have a slightly philosophical issue or challenge with that. About, well, if one at the same time employees are now permitted often to work from home a lot of the time, work from home certainly in a hybrid basis, so their lives are happier and freer. What facilitates that? IT, technology. And so I'm not sure it's right to take the benefit without some of the burden. The other issue is, I don't see how, if you introduce this law, how do you quantify the loss? If you've received an email at 7:30 on a Friday evening from your boss, which you object to because your working time, your contracted hours finished at 5:30 or 6, and you receive an email saying, can you look at this first thing on Monday morning? On the face of it, that's a breach of the right to be, as it were, ignored in relation to your working time. But what's your remedy there? What's the cost to the employer? What are the damages against the employer?
Yeah, I think what they'll do is introduce a penalty. It'll probably be a penalty of, say, 4 weeks' wages, something like that, as a disincentive to employers to actually contact outside working time. That can be the only reasonable means of enforcing it, and that will be subject to a claim in the tribunal and probably a day one right. But I've not seen any comments on that generally. But I think it's a little bit like some of the other. If you don't issue a contract, then there's a right to claim between 2 and 4 weeks' pay. A sort of penalty, that sort of thing. What do you think?
I think that's right. But of course, if they did it in relation to each instance of illegitimate contact for each employee, you could be talking about hundreds of fines per weekend per employer. So I think the way in which they monetize this potential claim for employees is going to be really interesting. And so for me, it's less about the introduction of this proposal and more about the enforcement. I mean, if the government were to issue guidance, non-binding guidance, saying people have the right to increase privacy, the right to increase time off, that's fine. But giving people enforceable rights is slightly problematic, I think. Am I able to speak about the one big thing?
Of course.
And that is this: the single biggest driver, and it's a kind of hybrid employment law issue. The single biggest driver of economic growth in this country will be business immigration, and the extent to which the Labour government tacked closely to what they've said in advance of the election, which was to neutralise migration as an issue in advance of the election. And congratulations to Keir Starmer and his team. They've won a stonking majority. They have succeeded, at least in part, of that aim, and Reform have also done better than predicted. So, that's a big issue in this country. But if you talk to most sector-specific business organisations, the ability to liberalise the workforce, to get more economic migrants into this country, will be the single biggest determinant of whether this country is able to achieve its growth aims. In particular, the last big issue that Labour trailed in the previous weekend before the election was house building. It was the number one issue on the Sunday Times in the weekend before. And if you talk to the UK House Builders Federation, they will say the number one biggest drag on the ability to build houses in this country is the lack of people, skilled workers, to be able to do that. So that, to me, is the biggest thing that the new government has to resolve. Are they going to put the concerns, effectively, of red wall constituencies and voters first, or are they going to put the concerns and desires of business first? Because the two compete, they jar for perfectly good reasons, and the question is, how is the new government going to resolve that tension?
Yeah, I agree with that, John. I think we do lack skills. We lack skills in a number of industries, but particularly construction. We have a woeful need for new housing in this country. And it doesn't matter what money we put into that. If we don't have the skills to build those properties, then we're just not going to make an advance in that area. So, and it will be challenging to balance those interests of restricting immigration, but also requiring those skills. And I don't think there's an easy answer to it. If Labour get this right, then fantastic. But I don't know. I don't know what's going to happen really. But we do need the skills, certainly in construction. So yeah. So what's your overall summary of these proposals, John?
I get where Labour's going. I think that what I'm really interested about is Starmer and Reeves presenting themselves as a very safe, almost boring pair of hands in advance of the election, and they've won the majority. So they've persuaded the nation effectively that they're not going to frighten the horses. Actually, in employment law proposals, these are radical proposals if the Labour Party is going to see them through. I'm not sure, and I think you're not sure, to what extent they do support the Labour Party's number one aim of driving business growth. And I think it's going to be that tension that we see play out over the next 6 months that's going to be, for me, the most fascinating thing in this new government, the extent to which this historic commitment, which the Labour Party has had for over a century, to increase the lot and the working rights of employees, of workers, how that historic commitment is aligned with their stated aim of achieving economic growth. And that is going to be the fascinating thing to see how that plays out between now and Christmas. We live in interesting times. We've had 14 years of a previous government. We've now got a Labour government. And let's see how they handle things in the months and years to come. But it's interesting times to be an employment lawyer. It's an interesting time to own a business. It's actually an interesting time to be an employee or a worker. So for all of us today, this is a new landscape, and we do live in very interesting times. Really good talking to you. Thanks for your time.